Welcome to Frank Bruno Law. I am Frank Bruno. Today I'd like to speak about guardianship. Before I get to that, if you would like to make an appointment or speak to me by telephone, please go to callfrankbruno.com or read my blog at frankbrunolaw.com. Today I received a call from a woman that had a guardianship over her grandson. So she called me looking for guardianship, and the nature of it is that she wanted to transfer the guardianship out of state to another relative. And she went to my website, saw that I did guardianship. I have an associate. We also handle issues related to divorce and family law. So the guardianship comes up twice. It comes up as a family court matter, and it comes up as a Supreme Court or even a surrogate's court matter. But this particular woman really needed a family court guardianship. So let me give a little explanation. Guardianship is a term that can be used in 3 different courts. So in the family court, a person can become a guardian of a minor child, and that guardianship can last up to the age of 21. That type of guardianship is it fulfills a parental role. So the parents' rights are not terminated, but they're suspended, they're put on hold, they're not at the forefront. The person that has the guardianship takes on the parental role, can make decisions for the child with respect to health, education, welfare, and typically that child will live with the guardian. So that's one type of guardianship. There's a guardianship, and in the family court, related to this guardianship, there's no issues of money. If that guardian wanted to obtain any type of child support, they would have to file a separate child support petition. Other than in the child support part, family court does not handle issues related to money. And if they do, they're only in one distinct part for a certain set of reasons. There's a second type of guardianship, and that takes place in the Supreme Court. And that's when one person puts forth a petition to be a guardian of either the person or the property of an individual alleged to be incapacitated. And that's for an adult. It's for an adult person based on some type of incapacity that they have. There's a similar but different proceeding that can take place in the surrogate's court. The surrogate's court can one person can apply to be the guardian of an adult, incapacitated, someone that is not able to make their own decisions. Maybe they're suffering from some type of disability. It can all, in the surrogate's court, a person can also apply to be the guardian of a minor child for issues related to money. So say a child, a person has to be, would like to be the guardian of a child, and that child has a sum of money or has inherited property. That's why you would go to the surrogate's court to be the guardian of that person and of their property, and property meaning money, not just real property or anything to do with land. So that's a brief little synopsis on why guardianship is in 3 different courts. If you would like to speak to me about your case, if you have anything to discuss, please go to callfrankbruno.com. Thank you.